Good morning, everyone, and welcome to our public inquiry webinar on the Covid-19 inquiry. So you can see us on the screen and you can see us on a slide. I'm Daniel Irving. I'm a barrister in Burkitt's Regulatory and Corporate Defence team. I've appeared in a number of prominent public inquiries, both prior to joining Burkitt's in independent practice at the bar and since coming to Burkitt's. They include the Iraq inquiry, the Chilcot inquiry, the undercover policing inquiry, and Francesca and I currently represent a core participant to the Grenfell Tower inquiry and have recently been instructed in the Covid-19 inquiry that we're speaking about today. I also appear regularly in the Crown Court on criminal matters and advise across a range of regulatory matters.
And hi, I'm Francesca. I'm a solicitor in the team, and as Dan's explained, I've been working with him on the Grenfell Tower inquiry for a couple of years now. I also work in health and safety defence and prosecution and coroner's inquests.
Francesca and I are part of a wider regulatory and corporate defence team here at Burkitt's, and that team predominantly deals with prosecuting and defending health and safety cases, public inquiries, coroner's inquests, and white-collar crime. This is the wider team, and then obviously we're part of a full-service law firm here at Burkitt's with specialists across the breadth of practice areas. It means that we can offer expertise in the areas of law that a public inquiry may touch on also. And I'm going to hand you over to Francesca, who's going to deal with the first part of the webinar today.
Yes, the reason that you're all here. So the first question really I expect that some of you are wondering is why a public inquiry in terms of COVID-19 and not one of the more usual mechanisms for justice, such as criminal prosecution or a civil action? Well, the all-encompassing term for an event that might trigger a public inquiry is matters of public concern. However, there's no official criteria to indicate what this might actually constitute. And I think that that's been a very deliberate decision. Guidance suggests that the most common characteristics of events triggering previous inquiries are large-scale loss of life, such as was seen in the Grenfell Tower inquiry, serious failure in health and safety issues, as examined in the inquiry that resulted following the Hillsborough disaster, a failure in regulation. The undercover policing inquiry is a very good example of this. And then the sort of broader example of other events of serious concern, and this would encompass issues such as those seen in the Stephen Lawrence inquiry and the independent inquiry into child sexual abuse. Now, most of us who haven't or had any direct exposure to criminal or civil proceedings still have an understanding of the features that sorry, just had a little warning light that's come up on the screen, so I'm just going to pause for that to go. There we go. Yes, the features of the adversarial legal system insofar as it aims to apportion liability and either establish guilt or innocence, or in the case of a civil trial, award victory or deliver defeat. Now, one of the fundamental points to take away from this webinar today is that the inquisitorial process is largely antithetical to this. And in fact, one of the hallmark features of a public inquiry is that it cannot determine civil or criminal liability. So at this point, you might be wondering, well, if an inquiry panel is precluded from establishing any liability, then what's the point? And essentially, the purpose is to establish simply what happened, why did it happen, and perhaps who's to blame, but more importantly, what can be done to prevent this from happening again. And the main aims of the inquiry are focused on the following areas. So establishing a full and fair account of what happened, learning from events and helping to prevent their recurrence. Catharsis and therapeutic exposure is also a very legitimate aim of public inquiry. Reassurance and rebuilding public confidence, and I expect that we'll see some attempts at that with the COVID-19 inquiry. Accountability and political considerations, often providing a leverage for change. And it's easier to appreciate in the context of the ambitious objectives above, this preclusion from determining liability is pretty crucial in order to aid this culture of openness and transparency, because arguably an individual giving evidence to the inquiry would be far less inclined to be candid if they were giving that evidence in the shadow of a potential finding of liability. Now, you're probably already aware the UK Covid-19 inquiry is chaired by Baroness Hallett, who put a great deal of thought and preparation into the terms of reference for the reasons I've already explained. Baroness Hallett was called to the bar in 1972. For a bit of background, in 1989, she became a QC, and she was the first woman to chair the Bar Council in 1998. After becoming a presiding judge, she was then promoted to the Court of Appeal in 2005, and she was appointed Vice President of the Court of Appeal Criminal Division in 2013. Now, probably the second most important figure, some might even say the most important person in the inquiry team, is lead counsel to the inquiry. And this role's been filled by a man called Hugo Keith QC. Oh, actually, sorry, this says QC, but of course now it should say Casey. My notes say Casey, QC, sorry. Now, as lead counsel to the inquiry, Hugo Keith, his role is to give independent legal advice to the chair. It's to present the evidence and to question the witnesses that are called, and to lead the wider counsel team. He won't do it alone. He'll have probably other cases working with him. And Hugo Keith's got a reasonable amount of experience. So he was a member of a panel of Civil Treasury Counsel for 8 years, during which time he regularly appeared on matters of public and criminal law in the High Court, the Court of Appeal and the House of Lords, and he has been instructed in many of the leading extradition and white-collar cases of recent years. And quite interestingly, he represented the royal household in the inquest into the death of Diana, Princess of Wales. He was appointed as leading counsel to the inquest into the London bombings of the 7th of July 2005, and he subsequently appeared in the Leveson inquiry and the Mark Duggan, Alexander Litvinenko and Westminster inquests. The teams also appointed Ben Connor to the role of inquiry secretary and Martin Smith to the role of solicitor to the inquiry. While these are less visible roles, if anyone watching today does end up becoming a core participant to the inquiry, it's likely that you'll receive some correspondence from either Martin or Ben, albeit via your legal representative. Now, the aims that we've discussed so far provide the foundation for establishing what's known as the terms of reference for the inquiry. And these terms set out the matters to which the inquiry relates and the facts to which it needs to determine, whether the panel is intending to make recommendations, and any other matters just relating to the scope of the inquiry. Now, you may have seen that Baroness Hallett put her draft terms of reference out to public consultation for a period, and she was pretty keen to invite feedback. Now, this is a clever move because the terms of reference must be drafted with absolute intention and precision, because they essentially direct the focus of the inquiry. Terms which are too short, too broad, or that lack focus will cause problems later down the line. And a really good example of this is the infamous Bloody Sunday inquiry, for which the terms of reference consisted of only 52 words. And because of the lack of precision, the inquiry took 12.5 years to reach completion and cost £191 million. In meeting its aims, the inquiry will consider any disparities evident in the impact of the pandemic on different categories of people, including but not limited to those relating to protected characteristics under the Equality Act 2010 and equality categories under the Northern Ireland Act. They will also listen to and consider carefully the experiences of bereaved families and others who have suffered some hardship or loss as a result of the pandemic. The inquiry will not consider in detail individual cases of harm or death, but listening to these accounts will inform its understanding of the impact of the pandemic and the response and of the lessons to be learned. They will highlight where lessons identified from the preparedness and the response to the pandemic may be applicable to other civil emergencies, and have reasonable regard to the relevant international comparisons. And the inquiry will produce its reports, including some interim reports, and any recommendations in a timely manner. The aims of the terms of reference for the COVID-19 inquiry are detailed and relatively long, so we'll examine them broadly first of all, and then take a more detailed look. The terms are split into two main sections, with the first containing the majority of the detail. Section 1 aims to consider the Covid-19 response and the impact of the pandemic, including the public health response across the whole of the UK, the response to the health and care sector, and the economic response to the pandemic and its impact, including governmental interventions. And we'll go into these sections in more detail momentarily. Section 2 of the terms is much more succinct, but no less important, and it's very much in keeping with the spirit of all public inquiries in that it aims to identify the lessons that can be learned for any future similar events. Now, as you can see from the slide, Section 1A is very ambitious and it aims to cover a huge number of areas. So I'm not going to read them out simply, in terms of all 22 subsections, because you can see them for yourself. Clearly, Baroness Hallett and her team are preparing to examine issues such as the availability and use of data, research and expert evidence. Some of the topics which until 19 were not even a part of our vocabulary, such as shielding, lockdown, social distancing and face coverings, and the impact of the pandemic on mental health and well-being, education and early years provision, and the impact of the pandemic on health and care sector and other key workers. So already incredibly broad. Section 1B aims to examine a broader range of issues, including the knock-on effect of the handling of the pandemic on matters such as non-COVID related conditions, antenatal and postnatal care and care in the home. Also nestled in there under Section 1B8 is the procurement and distribution of key equipment and supplies, including PPE and ventilators, which I imagine is going to be a huge task for the inquiry in terms of collecting and hearing evidence, given that there were so many controversies that surrounded this particular issue in the early days of the pandemic. The development and delivery of the vaccine will also be covered under Section 1B9, and again, I would expect this to account for a large proportion of the inquiry's work. Section 1C clearly focuses on what one would expect in terms of the economic response. I think it's very likely that Mr. Sunak will be expected to give some evidence personally, particularly when we're weighing up the benefits of the much discussed furlough scheme with the cost to the taxpayer. So in terms of how the inquiry will organise and set about its work, it's likely that this will follow a similar modular structure to that seen in the Grenfell Tower inquiry, if any of you are familiar with that. Although there's no mention yet, to my knowledge, about splitting those modules into phases, as it stands, 3 modules have been confirmed, and these are 1, resilience, planning and preparedness across the UK, 2, core political decision making, and 3, the healthcare system. Now, in 2023, I think we can expect to see further modules announced, and these will likely cover vaccines, the care sector, government and procurement, test and trace, government, business and financial response to the across the UK, health inequalities, education, public services and public sector. And the inquiry will also revisit issues in relation to Scotland, Wales and Northern Ireland. More information on further modules will be released apparently in due course. In terms of timing for the more public stages of the inquiry's work, preliminary hearing is actually scheduled for Module 1, and this will investigate the UK's preparedness and response to the pandemic. Now that's being held on Tuesday, the 4th of October, so quite soon. However, they're not scheduled to start taking evidence into Module 1 until spring next year. Similarly, a preliminary hearing will take place for Module 2 in late autumn, and Module 2 examines the UK's core administration and political decision making, which the inquiry will take evidence for next summer. And I'll hand over to Dan.
Okay, yes. So the first indication that you or indeed your organisation is likely to become involved in a public inquiry, and indeed the first contact most people will have with a public inquiry is by way of receipt of a Rule 9 request. Now, a Rule 9 request is the principal mechanism by which a public inquiry will gather evidence. Rule 9 of the Inquiry Rules 2006 enables a public inquiry to send a written request for evidence to individuals or organisations whom the inquiry believes have relevant information that may advance the investigation. The request will be set out in a letter from the inquiry, and it will direct the recipient to the issues with which it's concerned or should be covered in the response. It will usually begin with a questionnaire that goes out to individuals and organisations, and that the inquiry believes will be able to shed light on issues that are directly relevant to the terms of reference that Francesca has already referred to. Now, from previous experience composing them, I know that Rule 9 requests from an inquiry are intended to be carefully drafted and designed to elicit the most relevant information. Understanding what the inquiry are seeking to ascertain, therefore, is increasingly important, and it will be, and you need to work out what will be relevant and should be included in the response. Getting it right the first time will reduce the likelihood of time-consuming follow-up correspondence seeking clarification or additional responses and documents. So if and when you do receive a Rule 9 request, if you haven't already, consider seeking legal advice. Whilst in-depth involvement may not be required at that early stage, what a public inquiry lawyer will be able to do is advise on crucial key decisions that may shape the nature and extent of your involvement as the inquiry progresses. So you should consider whether anything in the proposed response is likely to be of a sensitive nature, for example, and therefore that you'd request that it wasn't disclosed to the other parties. In ordinary circumstances, evidence submitted to the inquiry is disclosed to core participants, but restrictions on the publication of certain documents or aspects of documents can be imposed by virtue of Section 19 of the Inquiries Act 2005. But of course, your legal advisor will be able to advise on any proposed redactions to documents that you disclose to the inquiry, and will need to set out to the inquiry the reasons for each proposed redaction. The initial Rule 9 questionnaire will often be followed by a request for production of certain documents and or the provision of a witness statement. Now, witness statements provided to the inquiry following a Rule 9 request should generally meet a prescribed format, and consideration must be given to which documents should be referenced or included in any disclosure. Such requests obviously shouldn't be ignored, not least because the inquiry has the power by virtue of Section 21 of the Inquiries Act 2005 to compel a witness to produce evidence and relevant documentary material. Of course, legally privileged material and exchanges are exempt from that rule. One thing to note, the matters which the inquiry has asked about in an initial Rule 9 request will also, of course, provide a good indication of the issues that they're concerned with, and that they might focus on at a later stage with any follow-up Rule 9 request. For example, what information they'll be interested to hear about in a witness statement, and therefore how best to prepare for any oral evidence that you may be asked to give. Now, for public sector bodies, there are some public sector bodies out there, given the subject matter of this inquiry, that will inevitably expect or will have already received a Rule 9 request. And if you are out there and represent a public sector body, it's never too early to prepare. Rule 9 requests will invariably set a deadline for the response, sometimes quite a tight deadline, and compiling the necessary documents and drafting the necessary statements, it can be very time pressured and extremely labour intensive. So consider in advance how you may deal with a Rule 9 request that you haven't yet received but might expect to receive, and how dealing with that and managing that process is going to take the time up of your team. You should perhaps consider who the main point of contact should be within your team for any legal advisors, how you'll ensure you can identify and locate all the relevant material, and how the request might be communicated to the wider team to ensure that they understand everything as well, and how you might handle any resulting media attention. Now, as I said at the outset, we've recently been instructed in the Covid-19 inquiry and have therefore seen what at least one Covid-19 inquiry Rule 9 request looks like. And I can say in very general terms that it follows the expected pattern of the inquiry seeking a background and an understanding of the nature of involvement through the provision of a questionnaire. So what the inquiry are likely to seek through these initial questionnaires, these initial Rule 9 requests, is to understand how the individual or organisation's work and background meant that they came to be involved with or affected by the pandemic. More specifically, how their involvement and experiences will advance the inquiry's understanding of one of the aspects of the terms of reference. The Covid-19 inquiry is principally examining the success or otherwise of the UK's response to the pandemic. So the inquiry's initial questions, as you might expect, will seek to ascertain the impressions of those who were involved, those that were directly affected by it or directly involved in responding to it. And following that initial questionnaire, the inquiry may also ask what documentary material, both hard copy and soft copy, that the individual or organisation holds that may relate to an aspect of the terms of reference. The inquiry is also likely to ask that a list and full description of any relevant material is provided in the initial response, so that they can then ascertain what they might need to see. It's therefore important to consider at an early stage how your organisation will set about capturing all the relevant material. Where it is copious, this may necessitate devising search terms, and indeed it may necessitate the involvement of IT professionals, because an inquiry can and normally will ask for your search methodologies, because they will want to make sure that you have taken all the necessary steps to locate and identify all relevant material and nothing slips through the net. They'll then consider the response to the initial questionnaire and the lists of documents that you've identified as being relevant, and then perhaps come back to determine whether anything needs clarifying. There'll then be a fuller assessment of those responses, and consideration will be given to which documents should be provided to the inquiry in full. And that'll be based on that fuller understanding of what exists, what's in fact out there, and which individuals they may wish to have a formal witness statement from. So, final section of our webinar today is on core participants. What is a core participant? I suspect will be your first question, but it is really relatively self-explanatory. It's what you might expect. It's an individual or organisation who, by the nature of their involvement in the subject matter of the inquiry, merit an increased level of participation. Okay, so they've had an important role or been affected by the inquiry in a significant way, which means that they should, as of right, really be able to play a part in proceedings. And so in practical terms, what does it mean to be a core participant? What does it mean to have that right to play a part in proceedings? Those designated as core participants will be, first of all, provided with an electronic disclosure of evidence relevant to the particular subject matter of the inquiry, in respect of which they are so designated. So you might not be a core participant for the entire inquiry, it might just be for a certain section of the inquiry, and therefore you'd be entitled to electronic disclosure of all of the evidence relating to that section. That is, of course, subject to any restrictions that are placed on it by section 19, as I referred to earlier. Core participants will also have the right to make opening and closing statements of any hearing. They'll have the right to suggest lines of questioning to be pursued by counsel, and that's generally going to be Hugo KC, in fact, as Francesca referred to earlier, but you may find that there are other counsel on the counsel team that question witnesses, but the questions will most likely come through counsel. But you'll also, as a core participant, have the right to apply to the inquiry to ask questions of witnesses during a hearing. As I say, normally that will have to be through the counsel team at the inquiry, but on occasions, your counsel representing you will be afforded the opportunity to ask questions on your behalf. And this is all governed by Rule 5 of the inquiry rules. It sets out that the chairman may designate a person as a core participant at any time during the course of the inquiry, provided that person consents to being so designated. So someone can't be forced to be a core participant. That's important to say. But the chairman of the inquiry will at the outset assess who they consider should be a core participant, has the right to be a core participant because they're directly affected and will probably want to be a core participant, and will invite certain people to be core participants. And then they'll also hear applications, and they'll invite people to make applications for core participant status. So section 2 of Rule 5 states that in deciding whether to designate a person as a core participant, the chairman must in particular consider whether A, the person played or may have played a direct and significant role in relation to the matters to which the inquiry relates. B, the person has a significant interest in an important aspect of the matters to which the inquiry relates. Or C, the person may be subject to explicit or significant criticism during the inquiry proceedings or in the report or in an interim report. So it's one of those that you have to meet to be a core participant. Play a significant role, have an interest in an important aspect, or potentially going to be subject to explicit or significant criticism. The inquiry rules don't prescribe when an application must be made and considered, nor what form it should take. Therefore, designation can take place at any stage of the inquiry, but it may be because it may be the extent of the interests of some individuals or organisations are only discovered during the course of the inquiry process, and therefore an application is made or designation determined at a later stage when it becomes apparent that they do meet that test and should be afforded that designation. Normally, individual inquiry protocols will set out timetables for applications, and the Covid-19 inquiry has already published its core participant protocol, albeit not the timetable at this stage. But in it, it does state that applications for core participant status will be sought module by module. Details and timescales will be published on the inquiry's website, that the inquiry will set a time frame for applications to each module, and that applicants are asked not to submit applications outside that time scale, and that they won't consider applications outside the time scale unless an acceptable explanation as to why they didn't submit the application within the relevant time frame is provided. So it doesn't preclude applications coming outside that time frame, but there's got to be a good reason, and one such good reason may well be that it only became apparent as the inquiry progressed that this individual should be a core participant and did in fact meet the test, or indeed organisation. The inquiry's core participant protocol further sets out that the inquiry's terms of reference are broad. When considering applications for core participant status, the chair is likely to consider how any application relates to one of the inquiry's ongoing areas of investigation in each module. There will be few, if any, people or organisations who are designated as core participants for the whole inquiry, and that's what I referred to earlier. People and organisations are likely to be designated as a core participant for a particular section of the inquiry that deals with their involvement. So you may be wondering, what are the advantages of being a core participant? I've referred to them in brief earlier, but in fuller terms, core participants receive advance notice of evidence before it's published. This means that witness statements and documents disclosed by other parties will be provided to core participants ahead of witnesses giving oral evidence to the inquiry and ahead of the material being published on the inquiry's website. I mean, this can be a critical consideration in circumstances where you're preparing to give evidence, and particularly where decisions are taken that are likely to be subject of scrutiny. As an ordinary witness without designation as a core participant, you won't know what others have said in their witness statements about matters with which you were involved. And that's unlike, of course, in a criminal or even a civil trial, where as a defendant you'd have sight of the other witness statements and know what is being said about the action that you took or the decisions that you took. It means you won't know what is likely to be suggested to you by counsel to the inquiry. You won't have had sight of all the historic emails and the contemporaneous documentary evidence on the issue, and you won't therefore have had an opportunity to think about and recall in detail and properly prepare what your response would be to such questioning or even perhaps implied criticism. As a core participant, you have advanced sight of all the other witness statements and all the contemporaneous documentary evidence. It means you're able to refresh your memory about events that may have occurred some time ago and will be better able to anticipate what you're likely to be asked about and consider the evidence you can give on the subject. Court participants are also afforded the opportunity to question witnesses, sometimes through their counsel, but more commonly, as I said earlier these days, by suggesting lines of questioning and indeed specific questions that should be put to other witnesses by counsel to the inquiry. It means that where evidence is given by other witnesses that you know should be challenged, you have that opportunity to ensure it is challenged, perhaps to correct a false impression that might otherwise have been left in the minds of the chair and the inquiry panel. And it's the chair and the inquiry panel who ultimately draw conclusions for the final report. So it is important to have that opportunity to challenge the evidence of other witnesses, particularly where you might be expecting a degree of criticism if it weren't challenged. Court participants also have the right to make opening and closing speeches, often in relation to each module for which they are a court participant. It allows for individuals and organisations who are designated to set out their position clearly and publicly and to seek to influence the direction of the inquiry. The closing statement in particular allows a court participant to reflect and comment on the evidence heard by the inquiry, and it provides an opportunity to propose recommendations that the inquiry might consider making. Just as with submissions to a judge, where the aim and ultimate accolade is for sections to be transposed into the final judgment, closing speeches to the inquiry panel can serve as a useful source of analysis when they then come to write their report. Rule 13 of the inquiry rules outlines that the chairman must not include any explicit or significant criticism of a person in the report or in any interim report unless the chairman has sent that person a warning letter and that the person has been given a reasonable opportunity to respond to the warning letter. But Rule 17 gives court participants only the right to be given a copy of the final report ahead of its publication. So any person, individual witness will be sent a warning letter and an opportunity to respond to that warning letter, but only court participants, once that process has elapsed, will be sent a copy of the final report ahead of its publication. And this gives court participants some time to consider the conclusions of the inquiry and discuss the report with their legal advisors and perhaps prepare any media response that's necessary when the report is then released to the public, and prepare for any media attention, any questions that might be asked. So what then might be the disadvantages of becoming a court participant? Well, court participant designation can bring with it increased visibility, and for some, keeping a low profile may be preferable. For example, court participants are normally listed in a particular section on the inquiry's website. But where the actions or decision-making of an organisation or individual are likely to be scrutinised in any event, the witnesses will be giving evidence about these events, and staying under the radar may be an unrealistic expectation, irrespective of designation, and it can be a risky strategy to fail to keep up with the inquiry's work and the evidence it's considering. There are, of course, likely to be greater costs involved in being a court participant, which will inevitably be a consideration. Under Rule 21, public funding is available to those who have no other means to fund the cost of their participation. And the chairman, in considering whether or not to make a funding award, will take into account the following: the financial resources of the applicant and whether making an award is in the public interest. So not a great deal of detail in that test, and you may understandably think that Rule 21 is suitably vague. And as a result, inquiries very often publish protocols setting out the procedure and any additional criteria that the chair will apply when considering an application for a funding award. For example, the undercover policing inquiry costs protocol, that's what it normally comes under, stated that the chair that envisages that normally awards will be made only in cases where he decides that A, the applicant has a direct link to and evidence to provide in respect of the matters set out in the inquiry's terms of reference. You might have heard this before, you'll think it's the court participant test, and or has a significant interest in an important aspect of the matter set out in the terms of reference, and or may be subject to explicit or significant criticism. So the first part is do they meet the core participant test? But there are further aspects to consider. It's not as straightforward as that. It's then, does the applicant, or would the applicant be prejudiced in seeking representation if there were to be any doubt about funds becoming available and there are no other means by which such representation can be funded? And then finally, that it is fair, necessary, reasonable and proportionate to make an award. So it's, do they meet the core participant test? Do they have any other way of funding their representation? And would it be reasonable and proportionate, therefore, if they don't have any other means of funding their representation, to make a funding award? The COVID-19, that's of course the undercover policing inquiry cost protocol. The COVID-19 inquiry is yet to publish a cost protocol, but I envisage it will probably adopt a similar criteria. Of course, the final thing to bear in mind is that a core participant is expected to cooperate with any request from the inquiry for evidence or documentation in a timely manner. And so there is obviously a time resource question to consider also. And that, with the end of the core participant section, brings us to the end of this webinar. We do have some time for some questions, if there are indeed any in the questions box, but alternatively, as you'll see from the, we'll leave this up, do feel free to email us after the event if any questions come to you subsequently. Do we have any?
I don't think we do have any live questions. I think yeah, absolutely, as Dan said, please feel free if something sort of occurs to you, perhaps even once you've received the slides, feel free to email either of us with any questions that you have.